One of the questions I am frequently asked by callers contemplating bankruptcy is, will I lose my home in bankruptcy? There's an idea that you automatically give up your house if you file bankruptcy, and that's just false. In many cases, you are still able to keep your home after you file bankruptcy, even in a liquidation case like Chapter 7. There are several issues that would be relevant in Chapter 7 bankruptcy as to whether you get to keep your house. The first one would be, is there any equity in the property to begin with? It may be that you owe as much as the house is worth, or maybe you owe more than the house is worth, so there would be no benefit to your unsecured creditors for the trustee to sell your home in bankruptcy. And the trustee won't undertake that action normally for the benefit of the secured creditor, for your mortgage company. They have their own remedies. If you default, they can foreclose on your house. It's also possible that although you have some equity in the house, depending on how the title is held, the tenancy, and the type of debts that you have, it may be that the trustee doesn't have an interest in the property that would attach to that equity. For instance, if you hold your home in Virginia with what's known as a tenancy by the entirety, where you and your spouse own the house with the right of survivorship in that specific tenancy, if you don't have any joint debts, no joint unsecured debts, then the trustee wouldn't have the right to sell the property and go after that equity that you have. If there are joint debts, of course, the trustee could sell the house in order to pay those joint unsecured debts. The second issue, or the second big issue in Chapter 7 is, are you in default? Not only do you have to be concerned about the trustee selling your house in bankruptcy, but you also have to be concerned about your relations with the mortgage lender. A Chapter 7 bankruptcy will temporarily halt or delay a foreclosure sale, but it won't put your mortgage lender off indefinitely if you are in default. If there's no equity in the house and you're not in default to the mortgage, you should be able to keep your house. If there's no equity and you do have a default, unless you can make some arrangements with the lender, either through a loan modification or some arrangement to cure that default within a very short period of time, that lender could go into court, ask the judge for permission to foreclose, and proceed with the foreclosure sale in spite of your bankruptcy. Chapter 13 is a different story. Chapter 13 is often filed by folks for the purpose of keeping their home. Not only will you not lose your house in Chapter 13, but it provides a remedy, a procedure where you can keep your house and make up for the late payments, cure that default over an extended period of time, a reasonable period of time, so that you can keep your house. As an alternative, you also could propose to sell your house. Instead of letting your house go to foreclosure and have it sell for 50 to 75% of fair market value at a public auction, you could propose to sell the house yourself over a 6 to 12 month period, say. Now, in that scenario, you're not going to be able to keep your house in the long run, but you may be able to keep the equity, the value in it, because you will be able to sell your house at a private sale for a far greater amount than your house would sell for if it were sold at a public auction in Virginia. You should discuss with your own attorney how these particular aspects, these factors, may apply to your own case.